Council Bill 2001-254, a general ordinance repealing general ordinance number 6011. Amended Council Bill 2012-255, a general ordinance amending Chapter 78 of the Code of Ordinances of the City of Springfield, Missouri by repealing certain provisions of Chapter 78, Article 6, Section 78-261, relating to prosecuting marijuana and paraphernalia cases in municipal court of the City of Springfield pursuant to applicable city ordinances. And as I did at first reading, with your indulgence, Council Bill 2012-255 removes the expungement provisions and the Citizens Oversight Committee and increases the fine to $450. Council Bill 2012-257 has the same title, however, 256 is the same title, and it removes the expungement provision and the Citizens Oversight Committee. And Council Bill 2012-257 just removes the Citizens Oversight Committee.
Thank you, Ms. Cutter. We had public hearings on these 2 weeks ago, and we will be voting this evening. Before we vote, are there any comments by members of council? Mr. Brash, I believe you were first.
It has been instructive to hear the proponents of the marijuana ordinance explain the case. Although the rhetoric was at times strident and even abusive, there were many who expressed genuine concern for the handling of this contentious issue in a better way. I do believe they were sincere, but I believe they were sincerely wrong. For the citizens of Springfield, I recommend going to the city website and read what your top law enforcement, prosecutors, and legal counsel have to say. We asked for and received definitive responses from the Chief Municipal Prosecutor, Police Chief, and Greene County Prosecutor. My conclusion from reading this response and hearing the public testimony was that many of the concerns expressed at the public hearing have already been addressed. For example, in 2011, the Greene County Prosecutor had 10,628 criminal charges referred by Springfield Police. Of those 10,628, only 124 were misdemeanor possessions of marijuana as the lead charge. Of the 124, only 30 involved misdemeanor marijuana as the lead charge. According to the Chief Municipal Prosecutor, first offender cases of marijuana is a fine of $100 to $250. If the fine and the expenses were paid, this disposition can allow the offender, if he completes probation satisfactory, to avoid municipal court record altogether. Finally, in 2011, Springfield Police Department officers made 0 physical arrests for misdemeanor possession of marijuana as the sole charge. There does seem to be a problem with the initiative petition ordinance that, if approved, would conflict with state and federal law. The long and short of it, this ordinance is conceived, seems to serve no one, not the user of 35 grams or less, nor anyone else. In my judgment, the petition was poorly conceived and so legally flawed that to move it forward would be to abuse the system set up for citizens' involvement. As to voting for the public, I will leave it to others to determine if this initiative was treated fairly by not letting the people vote. The cost of $180,000 may have been worth it and the legal expenses if it had passed, but I'm not so sure. Unlike other initiative petitions, I conclude this one was so flawed that to go further would have served no worthwhile purpose.
Thank you. Thank you, Mr. Rush. Mr. Burleson.